there is a kind of status report received from the Chief Justice of the High Court explaining that the total human resource he has at his disposal and the total these objections or documents are required to be scrutinized. So there are 50 lakhs and they have been able to only, he doesn't have much more than the resource as per our order. If we go by the rank of ADJ or district judge, then 250 plus some retired 294, around that he has been able to muster this time.
220 CC not.
220 some. So right. Plus even if he adds some retirees, still that problem arises. So then going by the Chief Justice calculation, even if one officer decides 250 objections in a day, it will take 80 days. So this is in these circumstances that we are providing him that why we have taken up this matter immediately, that all civil judges also serving judicial officers with 3 years service, we are permitting him to utilize their services. That's one way out.
This is the letter.
So we are also permitting him now to take on board the retired or serving judicial officer from 2 neighboring states of Odisha and Jharkhand. And we are requesting the Chief Justice of both those high courts also to provide him, because that's the only.
That's fair. That's fair.
Only one thing can I say, that only the judges who are holding the NDPS court and the judges who are holding the POSCO court, they have been requisitioned up till yesterday. The honorable judges, the learned judges who are holding the NDPS court, NDPS and the POSCO, they have been requisitioned, not the judges from the civil side.
That we will leave the Chief Justice.
So that's the
leave it to the Chief.
That has to be completely his lordship prerogative. We will not say anything.
No, we agree, Maharaj. I think that's the question.
But if the judges come from the different states, they will not understand the Bengali Miller.
In the given situation, because there are 2, after all, one state is providing assisting officer, the other commission is being providing. The only way out is neighboring state. Let's go by the history also. Part of Jharkhand, part of Odisha was part of Bengal at one point. People still understand the local dialect. People have at least some familiarity with that. And there is no sending from Delhi, sending from Rajasthan, Punjab, Haryana is completely irrelevant. They can't perform. Only the neighboring states can do it. And that, of course, we are leaving to the, we are only strengthening hands of.
Last option.
That will only.
That would, yes, that's right. That should be last option.
So, right on.
May I suggest one thing, if my lords permit? We are publishing a list on 28th. That would be final up to that, because that includes whoever they are there who have processed.
We are resolving.
We have also addressed
the next 1 minute. There's no time frame as far as the supplementary list.
Sir, we have addressed that issue.
We are trying to address that.
We have also
It
addressed.
can go on. What my submission is, minute.
Yes,
it can go on until the last date of nomination.
Exactly. Mr. Naidu, we have made that submission. We have included in further direction.
Yes.
We and my brothers had long deliberations.
We have sat about it, thought about it, and we have addressed these issues.
Great.
That you publish your list, but the exercise would go on. Supplementaries will be published, and they will relate back as a deeming clause to have been published on 20.
Precisely.
That is the idea. My brother,
democratic rights are preserved.
That's the
my
crux.
brother evolved this idea, and then immediately we both happily.
Lordship's order, Maharaj.
That's the crux of it.
Order.
We have to work out
Of course.
the best possible
Constructive
situation.
exercise, not.
The concerns in both sides are equally important, and we need to see the purity, sanctity of the electoral
The whole
vote
process.
on one hand,
One
and the individual rights on the other.
one thing just I point out to Lordship's kindly.
Says,
One thing, just one thing, just one. The rule is this, that the last day for the inclusion is 7 days before the nomination. Right, Miller? Unless
You don't consider, we are conscious of rules, we will exercise our repository powers
Mali.
to relate it back.
Mali.
Don't worry.
Mali.
So subsequent to our order date, 20th February 2026. We are in receipt of a self-speaking letter dated 22nd February 2026 from Honorable Chief Justice of the Calcutta High Court, from highlighting the enormity of the exercise to be undertaken in verification of approximately 50 lakh cases of inverted commas logical discrepancies to unmapped category. Inverted commas closed. Consequently, in order to address the issues raised therein, the matter has been listed today. And senior counsel representing the parties have been briefly apprised and heard. Next paragraph. The communication sent by the learned Chief Justice informs that 250 judicial officers of the rank of the district judge and additional district judge have been assigned the task of verifying and ascertaining approximate 50 lakh claims and objections of persons included in the inverted commas logical discrepancy stroke unmapped category. It is estimated that even in the event that each judicial officer disposes of around 250 cases per day, the entire exercise would stretch to 80 days. Taking note of this fact, and the time constraints, we are of the view that further clarification to increase the catchment area of judicial officers undertaking the subject exercise, streamlining the nature of inquiry and other ancillary matters are required to be further addressed through the following directions. 1I. In addition to the judicial officers already assigned the task, Honorable Chief Justice of Calcutta High Court would be entitled to draw officers from the rank of civil judges in bracket senior division and junior division having experience of not less than 3 years, so that an adequate and reasonable pool is created to undertake the pending verification work on a war footing. 2I. If the Honorable Chief Justice of the Calcutta High Court is of the opinion that further human resources would be required for completing the process, he is at liberty to approach the learned Chief Justices of neighboring states, namely the High Court of Jharkhand and the High Court of Odisha and the Odisha High Court, to provide serving or former judicial officers from those states of similar rank, who shall then also be associated to undertake verification work in the state of West Bengal. In that eventuality, the travel, boarding, honorarium, and other incidental expenses of such officers shall be borne by the Election Commission of India. Mr. Naidu, we don't want any vagueness that state will pay, you will pay, you bear the entire burden. And if you face any difficulty, then let us know, please.
Sure.
That shall be borne by the Election Commission of India. The land chief justices of Jharkhand and Odisha High Courts are requested to sympathetically and urgently consider any request that may be made by Honorable Chief Justice of Calcutta High Court in this regard. 3. For streamlining the nature of work, we clarify that the verification shall be with reference to the documents referred to in small a, notification dated 27th October 2025, issued by Election Commission of India, ECI, declaring the commencement of special intensive revision in the state of West Bengal, read with notification dated 24th June 2025 at the SO. B. The order passed by this court on 8th September 2025 in Petition Civil number 640/2025, whereby Aadhaar card was allowed to be accepted as proof of identity. And C. The order of this court dated 19th January 2026 passed in the instant petition, whereby Madhyamik in bracket class 2 admit card A capital C,
Class 10.
admit card and Madhyamik pass certificate M capital T capital C was also allowed to be submitted. Accordingly, we direct that all such documents, whether electronically updated or submitted physically with the necessary proof, on or before the cutoff date of 14th February 2026, may be considered. Fourth, it shall be the entire responsibility of the VRO/AERO to satisfy the presiding judicial officer of the documents referred to in paragraph 3 Roman 2 above, Roman 3 above. Next, the last date of publication of the final electoral roll is 28th February 2026. However, that being said, if the verification exercise undertaken in respect of inverted commas logical discrepancy stroke unmapped category remains incomplete as on 28th February 2026, the ECI may publish the final list followed by supplements to the final list. Such supplements shall be released, shall be published regularly on continuous basis, as soon as the pending exercise is completed in part or in full. The voters enlisted in such supplementary lists shall be we deem it appropriate to invoke our powers in the Article 142 of the Constitution and declare that the voters enlisted in subsequent supplementary lists shall be deemed to have been part of the final list published on 28th February 2026. That is ordered accordingly. Post this matter on so and so date.
But
That last option, your lordship said, neighboring states is the last option, your lordship said.
neighboring state last.
And the last option, your lordship said.
Neighboring state last
Invoking the
Neighboring state would be.
We have said,
Only that the Milord,
we have said, it is discretion of the Chief Justice.
It's a discretion of the Chief Justice.
the Honorable Chief Justice may take the help of the Milord, the retired judges of the West Bengal. Retired judges of the West Bengal.
Chief say, that's all.
No, that's now the new order has been passed. The retired judges of the West Bengal higher judiciary,
They are already there.
Milord, that is there, but since it is new order has been passed, it can be read that that part has gone. Milord, kindly
No, it's a continuation of the old order.
in continuation of the order.
We have used word in continuation and in addition.
That's,
Milord,
you also have said that.
May I just add one thing, my lords have referred to in the order, the documents that have been submitted by 14th of February, physical or soft copies, my lords. What has the process that we adopted was this, my lords. Whatever the copies they have given, we have uploaded,
Sir.
we have given a receipt.
The uploading itself is in some controversy.
That's right.
Because of the number of documents which were filed on or before 14. So there are certain documents which, as per our directions, there are endorsements, but have not been uploaded. So this is an area of document which our direction clarifies will be within the domain of verification.
And
But
in order to
documents
ensure,
after that would definitely not be considered.
and in order to ensure that there is no misuse of this part, we have said that the ERO and AERO will have to
Yeah,
certify it.
yes.
In fact, my lords, we have already done that. One is my humble submission, that once they have given,
No,
No,
Mr.
that was
Mayor,
the
you are
matter
not
of
correct.
controversy.
The exercise, what is happening is, because the volume is so much, the uploading takes time and the site sometimes crashes. And this is why by 14th, all the documents which were physically available were not uploaded within 14. Some have been uploaded after 14 and some have not been uploaded at all. It will be up to the ERO to clarify that they have received
Yes.
before 14.
Your concern can be,
Within 14.
your concern can be about those documents which of course were never uploaded and which were not submitted say till 14.
Yes.
But some, today we are on 24th February.
Yes.
Say for example, by now somebody has given document. We understand that. That's why the bonus is on them to show that the documents were received.
that's why, my lord, the fact remains, we have given the receipts. Not even one voter has complained that his has not been uploaded.
Let the judge,
That's no problem.
judge see.
So,
Let the judge
there's,
see.
except the political party's voter who has
You have undertaken an inquisitorial exercise, not an adjudicatory exercise.
No.
So we are not concerned with the voter coming up.
Yes.
We're concerned with the fairness of
At
it.
best, my lords, it only remains an allegation because we have given the receipt and that's been authenticated.
Correct, correct.
And
Let us say there is no receipt, out. But there is a receipt but not uploaded.
That's why,
Well,
That extent, they should have a right.
it's a demonstrable thing.
Exactly.
It's a demonstrable.
So
That's
it
why
will be
that's
the
so
ERO
important.
will verify and.
Could my lords, that clarification be given, my lords?
it is there.
You've already
There in the law.
My lords, if the receipt contains a document which has not been uploaded, certainly they will have a right to represent that one. If there is a discrepancy.
Why?
That may need,
The physical document will be seen by the judge with the verification of the
Precisely.
receipt and examined as to its veracity.
that guideline may be
You
added.
already said, read the order.
Milord, only one humble request,
Then the
Milord.
last one, my lords.
Just now.
The all the officers that have been deputed, non-judicial officers, my lords, we retain our disciplinary powers because we have to give directions, we have to rein them in, and we have to make them work.
No,
Don't have disciplinary powers.
no discussion.
I asked
What is-
Beg your
Notice-
lordship's pardon.
We have not asked you to relieve anyone. Whosoever you are,
Okay.
it is for you, your function.
There goes that.
My lord, it is practically seen, my lord, throughout the country. Most of the Aadhaar is made in the border districts. So I only request him, my lord, if lordship can add some one para, one line, my lord, to control this fake documents, fake Aadhaar, etc. my lord.
No.
We have already.
It has seen in, my lord, throughout the country.
Two things.
Whenever there are Bangladeshi Rohingyas are captured by the police,
You
the
are-
Aadhaar is from the Bengal.
Ah,
The document is from the Bengal. This is the practical situation.
how many documents
I-
you want
I am-
from the Uttar Pradesh?
I am placing it before the lordships with utmost responsibility, my lord, and request. This is the practical situation.
Mr. Pade, it may or may not be, because it will require a deeper probe. But this is not the timing of that probe, because least we are misunderstood by anyone. Let the right atmosphere and environment come.
Yes, my lord. But please see the consequence of this
For that.
matlab, direction in future. Because this SIR will become the benchmark for
Mr. Upadhyay, the best thing is the Solicitor General is there. You make a representation to the Union of India to amend the Representation of People's Act.
and even Aadhaar. Even Aadhaar, which allows the
Because we are dealing with the Representation of People's Act, the law as it's.
Whichever amendment needs, whichever enactment needs amendment.
Let Mr. Upadhyay approach the Solicitor.
I understand, but this is not followed the
This
proceedings.
cannot
in
be
which-
our forum for discussion on this. If Aadhaar has been fraudulently procured on a industrial scale, as you say, then it requires to be statutorily regulated because Representation of People's Act was amended. Aadhaar was brought in as a document which will prove identity. We have to acknowledge that.
but my lord,
Help us in that.
then lordships
approach the Union of.
lordships have reiterated the previous order. My lord, if lordships can
We
say
have clarified.
Aadhaar only,
Not be a-
identity only. If lordships add only one word, only, it will become crystal clear.
We have already clarified and
Our order is
this
very
order
clear.
also Honorable Chief Justice said for the purpose of identity.
Correct.
So there is no question of citizenship being
And
canvassed.
our other judicial orders passed in time.
Yes,
Yes.
as per usual.
My lord,
Deeply
the
obliged.
application with regard to uploaded documents, my lords, comparing with the receipts.
Okay.
Receipts issued by 14th February.
The receipts, the documents received by 14th February, whether uploaded or not, will be within the domain of the.
Based on the receipts issued by then, minutes. By
But this is
14th.
what you have not issued.
How could that be?
No.
Millets, they give, today they give
This-
some documents.
Why-
I give the receipt that day. It can't be 1 week later. That's all my submission.
It has, it can't, otherwise
opens
it's
a pander of-
extension of time.
That's what the lordships have said.
The ERO will vet and say.
Received and not uploaded. That's what your lordships have
I
said.
have given documents.
Well, I'm sure
And I
the
get
Chief
the
Justice,
receipt.
if he has any
Systematic-
problems, will seek a clarification.
It can be permitted.
If there is anything missing, it should be compared with the receipt you were given on that day. That's my submission.
Because
It
our,
needs to be.
if you recollect, Mr. Naidu, our order was there that when they are submitting the documents, they will be given a receipt.
Exactly. And it should be compared
After
with
the
that.
receipt, because there are some fake documents being created, etc.
Yes, yes.
Even the receipts can be created. That's the apprehension.
No.
It should be coterminous.
This is why our order takes care of that. If a receipt has been fraudulently created, correct? The ERO will immediately say this is not my receipt.
Absolutely.
That's the whole issue, Millets, to what extent the year was vouched for their conduct.
Sir, there are receipts available to the judicial officer of the ERO. He has a right as a judge under 73 of the Evidence Act to compare the two receipts. If this is a fraudulent on the face of it receipt,
Sure.
just
They should
throw
be
it out.
coterminous. That's all.
Grateful.
It means that the judges are well experienced to deal with issues of this nature and they will do a good job.
Should be.
Deeply obliged.
Let's hope that something happens.
Grateful,
Deeply obliged.
immensely grateful.
Please, Your Lordship, may I mention item 35, Your Lordship? It has been listed before Your Lordship almost 10, 12 times. But it hasn't been taken up, and it's a very critical issue pertaining to coastal remediation. And preservation of water bodies. Can it be taken up pre-lunch?
What is that? But it's saying something. Yes.
Item 35, I just wanted to mention.
Go on. No mentioning, please. Whosoever want to give, just give in writing. That's all. No mentioning. Don't waste our time.
My lords, may I mention from today's list, my lords?
Hmm?
May I mention from today's list?
Nothing to mention. Whatever you want to mention, give us writing.
My lords gave a liberty to mention that.
Whatever it is. What is so urgency in reverse?
It's the election of MLC matter, my lords had directed to item 54, my lords said. My tenure would be over, my lords had said.
Wait for the.
Lord, may I mention, I'm sorry to mention, because this is regarding appointment of judicial officers. Your Lordship is hearing that matter, now it is due on 11th of March. The order which is passed in our favor is sought to be reviewed by the High Court by issuing notice to us. That order we are challenging.
Let it be, we will see.
But this has to be heard along with that other petition. That's my request.
We will see, you file it, then we will see what is.
This concerns dispossession.
Your Lordship, apologies for mentioning this matter. Your Lordship, I have been under custody for more than 24 years and my furlough application has been rejected by High Court, Your Lordship.
Who is there in item 17? Don't disrupt when matter is going on, please. Who is there in item 17? Bail matter, but someone had to appear.
Sir, please, my lords, I appear, my lords, for the petitions.
Yes. Have you appeared?
Yes, my lords, as per the direction from morning 10 till 6:30, I appeared. I have fully cooperated with the investigation officer. He has given me an acknowledgement also that I have appeared.
No, there's no complaint about the answers given. He's cooperated as per the last order. However, my learned friend for complainant is saying that the last order passed by your lordships of payment of security, that has not been done.
Milords, there is one more thing which I want to add is that Milords, entire amount is paid by one of the co-accused who is the Milords person who received the goods. Milords, the principal, Milords, the person.
But he has not complied with the order of providing security before the learned trial court as my lords had directed in the order issuance of notice. My lord may just see.
May I make two submissions to that regard?
And this entire amount business is a false statement that accused has paid one part.
Must have furnished some security.
No, your lordship, he has not done anything. He has just gone to the police, met under my lord's orders protection, that's all. He has not furnished security as my lords had directed.
I am ready to furnish as your lordship directs, but lordship will consider only two submissions. One, Milords, the person who received the goods is on the anticipatory bail without any surety or security. Accused number 2, Milords, who is Mr. Milords Harish, he has paid the entire amount of the goods. It records in the Milords. I have filed an additional affidavit with the new document that entire amount of the goods have been returned to him. I am not a receiver, Milords. I have not gained a single penny out of this transaction. And Milords, as per the Milords, this can't be a recovery proceedings, Milords. There.
My lord, because the
bail matters are coming to Supreme Court. It's a matter of introspection.
I understand that requires some introspection, my lords, but maybe the amount for this is
not low, but I have joined investigation pursuant to our order dated 18th February 2026. That being so, the interim order, interim protection granted on 29th December 2025 is made absolute. Till the trial proceedings are concluded, matters can disposed of accordingly.
The entry may be continued subject to my lords furnishing the security as my lords are directed. That.
However, it will comply with all terms and conditions that may have been imposed by.
Grateful.
Great.
Item 18.
Please, my lords.
Yes, madam.
Yeah. My lord, here the appointment, he was not even having the eligible age. And after that, he changed the policy. All the powers of the UPPSC were being taken over.
Don't make this kind of half-hearted challenge, which looks like as if you are you are appeasing or pleasing some frustrated politician or someone.
No, no, my lords, even the petitioner was serving as the information officer. His appointment was challenged. He was made permanent.
And the secretary of the Legislative Assembly
Please, my
is
lord.
the prerogative of the speaker. Whether he would like to keep, he can't ask for a judicial officer. Because judicial officer, it's not that he will ask and the Chief Justice will provide. He will have to send a request, make out a case, Chief Justice will consider when he can spare on it. So the question of appointing a judicial officer rules out. Now you say public service commission. The rules have been amended. Under the amended rule, speaker is the chairperson of the selection committee. You don't challenge that rule. You are asking quo warranto person to select.
My lords, we are requesting for the writ of quo warranto because he was not even eligible for the appointment. We are questioning. Please, my lords.
Is it still continuing?
Yes, my lord, till this date, my lords.
Allahabad High Court में.
Even attaining
Otherwise, we are dismissing it.
my lords, the matter is already in the High Court and the High Court had stayed his working since year 2009.
Yes.
Still, the matter is not coming to be listed.
So we can't open a parallel
Proceeding. Better we go to High Court if you want.
My lords, kindly direct the High Court to expedite the proceedings.
No, please, no case to entertain this petition under Article 32 of the Constitution is made out. Petition is accordingly dismissed. However, the petition shall be at liberty to approve the High Court for my so advice.
This is again Allahabad High Court.
No, yes.
Yeah, sir.
This has become now your second matter also yours.
Please, my lords.
Second case is also yours, 19.
No, 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 my lord.
No, relief is almost same. Because that matter is pending in Allahabad. High Court will issue a direction.
Please, Lordship. Lordship, this matter has been pending since last 6 years before the Honorable High Court.
So, how many other old matters are pending?
Lordship, not even a single hearing has been commenced in this matter.
No. How many other matters are pending which were filed prior to your matter?
Lordship, there are numerous.
What is your age?
My 24.
This petitioner. Not yours. That we can have a reasonable estimate that you are a young lawyer. What is the age of the petitioner?
Lordship, she is 55 years old.
55 years old. How many senior citizen matters are pending who are 80 years plus?
Please.
So if we are to issue a direction, should we request the High Court to please take up those matters where persons are 80 years old, 85 years old, maybe some fortunate run of our old generation, 90 years old people are surviving. And they are surviving not that one of these reasons for their survival is that they just want to know the fate of their litigation before they give a final bid. So what about their matter? You tell it.
I did not.
You guys guide us, we will pass the same order as you want. वहाँ पे जाइए एप्लीकेशन फाइल करके मेक आउट ए केस ऑफ अर्ली
Please, Lord.
while we do not entertain this petition under Article 32 of the Constitution, the petitioner is always at liberty to move an appropriate application before the High Court and to make out a case for out of turn hearing of a case. With the liberty of formation, the petition dismissed.
May I please, your lordship?
Yes, please.
My lord, without following due process of law, my lord, we were asked to stop all our works
we have we have given our royalties, we have given the security deposit.
Well, you did not ask for the refund in the before the High Court. Where you kept on talking of all other issues. Where did you ask for the refund?
My lord, the representation that we had filed, for which we filed the writ petition, that was for the refund. My lord, may come.
Young man, in your writ petition before the High Court, where is this relief that my query has been closed, my lease period has expired, I have not been allowed to operate, and therefore they may be directed to refund my whatever fee you are depositing.
My lords, in High Court, we had approached to take action on our representation before ADM and DM. In that representation, we have sought for refund, my lords.
Yes.
My lords, may come to my representation, my lords. It's at Annexure P13, page 127.
I don't. The petition was granted a 5-year query lease for Keras and Bed dash Roman capital 3 pursuant to a public auction conducted in terms of notice dated 28th June 2018. The lease deed was executed on 25th April 2019 for a period up to 24th April 2024. The petitioner is said to have obtained environmental clearance on 14th March 2019 from PEIAA, Purana Vision and District Environment Clearance so and so forth.
The logic given for not giving refund is proper notice for.
Till 25th April 2024. Regardless thereto, the petition was served with a notice asking him to obtain fresh environmental clearance and consent to operate for the extended period of the lease. The petitioner had also deposited full royalty of his 12,80,701 on 17th May 2023. Next paragraph. Meanwhile, on 10th August 2023, the Deputy Director Mines issued an order stopping the petitioner's query operations on the ground that requisite permissions were not obtained as per the rules. The petitioner's reply did not find favor, and consequently a closure order was passed. The petitioner laid challenge to the above stated order before the High Court in a petition filed on 26th April 2024. The High Court has dismissed that petition entirely on the ground that lease period already stood expired on 24th April 24 and that the petitioner did not challenge the communication dated 10th August 2023 directing stoppage of operations. The High Court also indicated that the petition was suffering from delay as it was filed 2 days after expiry of the lease period. Next paragraph. As regard to the petitioner's claim for the refund of the royalty, the High Court in para 5 of the impugn judgment has said that since the petitioner did not challenge the communication dated 10th August 2023 and he has accepted the same and he is deemed to have accepted the same, hence claim for refund of the amount of royalty was not maintained. Next paragraph. The review petition filed by the petitioner has also been dismissed. Next paragraph. Though we do not propose to modify the impugn judgment of the High Court, as we have not issued any notice to the other party and we have not been heard at this stage, it seems to us that the petitioner had some truth in his representation from reply dated 18th August 2023 that in the event of closure of the query, he was entitled to seek refund of the royalty amount. That claim was never adjudicated by the authority. The High Court, to that extent, may not be correct in para 5 of the impugn order that the petitioner has abandoned that claim. Next paragraph. However, in the absence of the respondents, we cannot return a definite finding that we cannot return any definite finding petitioner's claim for refund of royalty amount. All that we propose to issue is a direction to the state of Odisha to the Department of Revenue and Disaster Management and Collector Sundargarh, Deputy Director Mines Raudipila, and other authorities that the petitioner's claim regarding refund of the royalty amount be examined and be determined by way of a speaking order within a period of 2 months from the date of receipt of copy of this order. In the event the petitioner is not found entitled to, or if his entire claim is not satisfied, liberty is granted to him to approach the High Court for the aforestated limited relief. Yes, further.
No problem.
I beg to appeal for the petitioner 21. This is a writ petition I've filed.
सुबह से देर बैठ जाओ कितनी रिट आनी शुरू होगी?
My lords, I will just point out my difficulty as I leave to my lords.
Point out is fine. What prevents you to move an application before the High Court?
My lords, I have moved 24 applications. My lords, I've given all those applications. I've given the case status of the High Court as Arranger P4. In my synopsis, I've carved out all the numbers, dates, and status of the listing applications that I've filed. I am a destitute widow. I have approached the High Court for compassionate appointment, my lords. Forest guard, my husband was a forest guard, expired in 2021, 2023, writ has been filed. Till today, the writ has not proceeded at all.
It has.
Family pension or
my lords, after his death, I don't have those instructions, my lords. My petition relates to compassionate appointment. I apologize, my lords. I don't have instructions on whether I am getting the pension or not. 24 listing applications, however, my lords. Pension, my lords, I have been told maybe the mother is getting the pension, but wife is not getting anything. Wife is the petitioner.
Casual retribution, don't give any particular facts, situation. It's in the Article 32 of the Constitution. The petitioner has come up with an unusual phrase. She seeks a direction to the Allahabad High Court for an out-of-turn early disposal of writ A number 10571/2022 pending in that High Court. The instant execution of the solitary instance, on an average, we face 2 or 3 petitions seeking identical relief against the same High Court. We are very clear and firm that in purported exercise of our judicial powers, we cannot take over the administrative powers of the Chief Justice of the High Court, who being master of roster, has the prerogative and has the absolute prerogative in prioritizing the listing of the matters of some identified category. That's what. As an exception, we find that the petitioner has very strong equitable considerations to persuade the High Court for early disposal of a petition. The sole bread earner of her family, as the petitioner's husband, was a first guard in Tiger Reserve Pili Beat. He died in harness on 2nd September 2021. The petitioner and her aged widowed mother-in-law are the 2 dependents of the deceased. She sought compassionate appointment as per the statutory rules of the state government along with no objection certificate from her mother-in-law. But her claim has not been considered so far. The agreed petitioner has approved the High Court. Two petition which is pending before, two petition which, as stated at the outset, is pending. Was any order passed rejecting your claim for appointment?
No decision taken, my lords. I was asked to furnish a no objection certificate, which is the contest, my lords. I say that is not required in the rules. For that purpose, it was kept pending. I approached the Honorable High Court. Now I am before my lords.
Next paragraph. A short question that has been raised before the High Court and reiterated before us is whether the petition is entitled to appointment on competition ground in accordance with provisions of the recruitment of dependents of government servants dying in harness rules 1974. Question mark. The petitioner, who was born in 1996, semicolon, having qualification of graduation from Rohilkhand University, semicolon, in whose favor succession certificate dated 11/10/21 has already been issued by Subdivision Magistrate Sadar, Pilibhit, coupled with the fact that the only other surviving dependent, namely the petitioner mother-in-law Srimati Indra Devi, has also given a no objection certificate. Primarily, it seems that the petitioner qualifies.
Somebody has not given the certificate. Came my mother-in-law.
It is given by the petitioner. Don't swear. Coupled with the undertaking given by the petitioner that she will maintain her mother-in-law during her lifetime. Primarily, it seems that the petitioner qualifies the eligibility conditions contained in the 1974 rules and her claim requires favorable consideration by the competent authority. Next paragraph. Consequently, and notwithstanding the pendency of a petition before the High Court, we direct 1I, the Principal Secretary, Department of Forest and Wildlife, Former Government of UP, 2I, Principal Chief Conservator of Forest, 2I, Chief Wildlife Warden, UP, next, the Divisional Forest Officer of Pilibhit and or any other authority who, under the rules, is obligated to consider her claim, with the direction that let the petition's claim for appointment on under the gracious scheme, stock rules, be considered and a final order be passed within 2 months from the date of receipt of copy of this order. The authority shall be at next order. The authority shall be at liberty to impose such reasonable terms and conditions while offering appointment to the petitioner, as they deem necessary for the purpose of sustenance, maintenance, and a dignified life for the mother-in-law of the petitioner. Mother-in-law of the petitioner. Next one. In case the petition claim is accepted, her petition before the Allahabad High Court shall stand and shall be rendered in force. Next one. However, if the petition's claim is rejected or partially accepted, she will be at liberty to seek amendment of the pending petition. It is a further request to the High Court to accord out of turn hearing. Out of turn hearing and subject to other parties. Out of the court.
Extremely grateful, Lord.
Yes.
Lords, my plea for green energy and clean energy is not seen by the residential societies, my lords. I've written to them many a time. There's already a policy in place. Just if the policy is implemented appropriately, the policy is in page number 44, my lords. It's grateful, my lords.
You hope that you don't have commercial venture in mind.
Not at all. Grateful, my lords.
Wait, please, madam. The office could indicate that that the identical issue is also pending. Lord.
Why people keep that
pending, my lord, because I have raised the aspect of section 26 of the act as well, my lord. Apart from what has been raised in the earlier petitions and the exact
what is his concern, by the way?
No,
last week also he had filed his chronic litigant appears.
My lord, there is an additional issue I have raised, my lord. That is all I have. There is an additional issue of section 26 which I have raised in my petition, my lord, which is not there in the earlier petitions, my lord, which has been.
We are only on this mushroom growth of JL petitioners. Why some faces become so identifiable? Every day they keep, at the morning, I think the only agenda is to read the newspaper, create an item, and rush to the court.
This petitioner has, on the earlier occasion, also has raised few issues with respect to the education reforms, my lord.
No, this matter has already been taken up. As far as you are concerned, we can always seek your assistance in the matter. In the pending case, you can always provide us assistance. You will add one more petition, notice, pleading, and the main lead case, then it will be ready. That is what is happening.
I will bow down to my lord. I can only request, my lord, if it can be simply tagged along with that matter, my lord, sharp actions of the notice because of the aspect of this section 26 which I have raised, my lord. Deeply obliged.
Please, my lord. Lord, the petitioner herein has been declared an illegal migrant, my lord.
When was it declared, madam?
I'm sorry, my lord.
When was it declared?
My lord, it was quite some time back.
You are the master of the facts of your case. You must be everything on tips. You are not required to see your laptop. The date must be verbally known to you.
My lord, as back as in the 70s.
वो भी इसका मालूम नहीं 2005
In 2005, he has been declared an illegal immigrant. However, my lords, as an officer of the court, I understand my position before my lords, but I'm beseeching this court only, my lords, to give the petitioner a last chance only to demonstrate the documents that he has, my lord, which shall be decided on its own merits, my lord.
The problem is that in all these 20 years, he must have forged all the documents. Today, when they were saying in SIR matter, that how documents are forged, it's not that we don't live in ivory tower, we know it very well.
My lords, I understand.
I can get my own duplicate passport, I can get even driving license, anything in this country readily available.
My lords, I say so because his brothers and sisters have been identified as legal citizens of this country, my lord, but he has been ousted.
But only because it initiated timely legal process. Now, unfortunately, 2005 matter, you don't do anything.
He's a poor layman, my lords. Otherwise, I would not have insisted, my lords. He's a very poor, marginalized person, my lords, not knowing his rights and, my lords, the process of the court. And I wouldn't want to stress, my lords, but unfortunately, he has not been given proper assistance by the lawyers that he hired before, my lord. Well, this is the only last ray of hope he has, my lords. Only the documents to be examined on its own merits, my lords. If they are not correct, my lords, he can be ousted from the country.
Which is the document of pre-2005?
There's an admit card.
My lords, there's a admit card.
तो मैडम क्या
24 साल से नहीं निकाला है वो एडमिट
we will not be able to say no to anyone. Because 2005 and today in 26, suppose you want to show some document, what is logic we give?
But since the order was passed,
We understand a person is poor. We provide legal aid to him. He is not his case that he approached anyone.
indicated also.
He is not completely illiterate also. It's not that he is educationally backward, so backward that he can't. Please show us a single reason on the basis which we try to stretch our discussion and create a case which does not become a bad precedent.
My lords, I am only beseeching this court, my lords, because the order was passed in his absence ex parte, my lords. Only considering that aspect, my lords.
Ex parte order, if it was passed, then against that order, number one, he could go seek recall of that order. Or he could timely challenge that order before some authority. When it is not his case also that he came to know only on so and so time.
Yes, my lords, as far as that is concerned, I bow down, my lord.
That's why we are saying that how to find out a way out.
If my lords may consider limiting it to the facts of this case, my lord.
Facts of this case are all similar facts. Did you attach the document with the review application?
review application है huh?
Yes, with the review application, my lords, I have annexed all those documents.
Seven. How do you answer to that?
My lords, I have been instructed that he was not given proper legal advice, my lord. That is the plea that the petitioner takes.
First petition also this admit card was not annexed. First petition also it was not annexed.
Don't attach the document.
Yes.
Nothing is.
Now today if you interfere, what the High Court judge will also feel. It's not, had it been a case of suppose review dismissed with one line,
Please, my lord.
even then we could say, please examine the review, it's a matter. The order in the review is bigger in size as compared to the main judgment.
Lords, I'm in your lordship's hands, my lord.
In the evidence given by your brothers,
Please.
where the brothers are declared Indian citizens, they do not refer to you as a brother, co-brother.
Yes, my lord.
They have spoken of their families,
Right.
no reference to you.
Yes, my lord. However, the father's name is the same, my lord.
Father's name is the same, is founded on an admit card which comes out after 20 years, right?
Yes.
Now, if a brother is accepted as an Indian citizen and has given evidence that I am born from A and B, and our family consists of 4 brothers, myself and 3 others.
Please.
Your name does not feature. You've seen that?
Yes.
What did you ask?
I'm grateful for my lord's patient hearing. Great.
No, this concerns security, because, and in the normal circumstances, I know the court.
There are better security agencies providing much efficient security cover than
the point.
police.
I'll tell you lordships what.
Get out of that hangover of Burdi.
Look, that's not the point.
The hangover should go out.
Let's look at
You are a powerful
More of
man.
status
I am
level.
not. I am no longer a powerful man.
You were a powerful.
That's my
Okay,
father's.
you are not powerful
six
by
of
state
siblings.
power. You are powerful by money power. So use
My
your
father
money
and
power
6 of
by your
siblings.
security.
Look, my father and 6 relatives are hacked to death.
उसका 24 में इलेक्शन में लॉस हो गया है और उसमें ग्रीवांस सर के हाँ वो opponent
Look, the
grievance is not your loss. The fact that your opponent is being given security cover.
He has threatened me.
That's it.
Page 47, he threatens me. He is now being provided with security. Your lordship, he belongs to the ruling dispensation. He is being provided security. Clause 7 of the policy, would your lordships one kindly only see
status symbols, that's all.
It's not about that. Your lordship see the clause 7 of the policy. There is a policy. I make out a case within the policy or I am out of the court. Would your lordships kindly see the policy, page 39 for a minute. Clause 7 of the policy. Page 39.
It has nothing to do, it's all threat perception, that's all.
The threat perception.
Threat perception.
The threat perception
it is the state, why to have even a PSO? The state's obligation is to protect the life and liberty of every citizen.
That's right.
For that, they have to create an environment. You are also there, the other citizens are also there. You are no threat to anyone. Nobody is threatening you.
I am grateful. The threat perception can't be any different because 6 people have been hacked to death in my family. The person who says,
right.
That's right. The person who says he will, the person that Malina.
That is more euphemistically saying that your tongue will be cut.
Kindly see page clause 7.
Doesn't mean that he's going to physically come and cut you.
How else do we take threat perception? Kindly see page 39, clause 7.
Seen
if your lordship.
And it's a very mild expression in particular states, some of these states. The kind of language they use. They use very aggressive language.
Some comments about him.
That's you know where it is. Either you fall within the policy or not. Exactly for the instruction. Someone to estimate for us. decided to send it. Support the field research. That's what I'm saying. Oh, that's after. It happens after. That's why I'm saying. So far as the review committee is concerned, the single judge holds, after perusing the review committee's recommendation, would your lordship see page 88, he says
Fresh consideration.
He says only fresh consideration. He says it is not objective. What they do on the contrary is in April 25, put me under house arrest saying there is a threat to your life. I go to court asking for protection. Kindly see that order at page 80.
No, that is because if you go there during that ceremony, there was a fear that you will generate again violence.
You see the action of the state. Remove my security, put me under house arrest. My opposite faction is given full security. Clause 7 of the policy now. Page 80, 81, your lordships have seen I was put under house arrest. Now see clause 7 of the policy under page 39. If there are two factions, the court says you can't give only one faction security. The policy is that, sorry, not the court, the policy is that clause 7 at page 39. In respective factional groups, security should not be given to the affected party.
Why public exchequer? Why?
Plus, I am paying. I have already deposited the challan.
Keep it from the private security. You again the private agency nowadays.
I have now deposited the challenge pursuant to
What prevents you to hire a private agency, dedicated agency of your choice?
Because I am a member of the opposition party. Yeah. I am a member of the opposition party. There is no doubt about that. The ruling party
leader of the opposition.
The ruling party member gets.
You are not leader of opposition. LOP.
No, not that. Not the LOP. I am saying I am a member. That's why I said I am a member of the opposition party.
Lost 24 election. If you won 24 election, you will by itself get
the more reason. If it's an LOP, I would have gotten security.
People are not liking you. 500 rupees, 1000 rupees, obtain a membership of a political party and then start your position. That perception has to be assessed by, there are intelligence agencies, they have scientific reasons and they have very objectively based criteria to assess.
By the single judge. The threat perception is perused by the single judge. A security report is called for perused. Look at the arbitrary conduct. You say the single judge says I have perused the security committee's report. That review committee's report is not objective. You place me under house arrest. My opponent is given protection by the police. Where is the question of there being any reasonable action on account of the state? With all due respect, either I fall with the policy or don't fall with the policy within the policy. Question is, there's a reversal judgment by the DB. The DB also doesn't apply its mind. 3 times the DB, page 99, 100, 101, the DB calls for a report saying, why have you given security to only one side or the other side? That orders are completely given a go by minutes in the impugned judgment. There is not even a reference to those 3 orders.
So, to provide security cover has not been favorably entertained by the High Court. After evaluating the threat perception, for which a report from the specialized agencies were taken. There is a state level security review committee who assesses the threat perception on the basis of the input received from the specialized agencies. It is true that the petitioner is one of the members of the political party in opposition, but that per se may not be a valid ground to presume that he has any threat perception. Next one. At the same time, there cannot be a static approach to the issue of danger to one's life and liberty. The situation, depending upon various circumstances, keeps on varying, and occasions can arise where the level of threat perception to the petitioner might be also such degree which may warrant the law and order machinery and forcing machinery to provide adequate protection at his own expense. So, however, these are not the issues warranting judicial adjudication. Such delicate issues will have to be left to the law enforcement agencies, who are obligated to ensure safety to the life and liberty of every citizen. Next one. We have no reason to doubt that the concerned authority will reassess the threat perception to the petitioner, if any, after periodical breaks, and will take an appropriate decision as may be required, depending upon the outcome of such reports.
Grateful.
Upon the outcome of such assessment.
The court has damned me, my lord, completely, without even as much as issuing notice to me to start with. My lord, I came to know after the commissioner's report. Now the High Court says you file a response. After, my lord, writing 25 pages against me. Now I show your lordship, my lord, the High Court was prejudiced by certain facts, but I wanted to show, my lord, I never got an opportunity. Now the judge gives me an opportunity in para 53. If your lordship turns to para 53. Para 53, my lord, page 21. After, my lord, whole Ram Kahani is over, my lord, at page 21, para 53. Liberty is reserved. Page 53, page 21, bottom, my lord. Liberty is reserved to the petitioner and the private reserve to clarify the stand light of primary observations made by us. It's not after 30 pages, my lord, which is writing. How is it prima facie now? Now, my lord, now, my lord, see one by one. Yeah. The first petitioner is, my lord, a mining contractor adjacent to me. He files a PIL. My lord, see the name of the first petitioner itself. He is, my lord, a contractor next to me.
He is also condemned, paragraph 49.
That's right. So, my lord, he doesn't go to NGT. He has a right to go to NGT. My lord, the mining is over. Mining was 10 years from 2016. It ended, my lord, in 2025.
But the advocate commissioner goes there and hears blasts taking place.
How, my lord, somebody, it must be his blasting. He records that my mine is over, my lord. There are 3 mines in the vicinity. My mine is over. It is recorded by the commissioner himself. My closure plan is pending, my lord. It was 10 years from 2016. Your lordship may know 2016 to 2025. My lord, it is closed. It is recorded. It is closed. The blast he hears must be from that fellow's mine, my lord, which is next to me.
So go and tell the High Court that blast it
But-
to your neighborhood. Not to-
No, my lord, High Court has now sealed it. I don't know what is the purpose of sealing, my lord, a closed site. I'm not mining anymore. I stopped, my lord, 6 months ago. High Court has sealed the site as if it's a forensic site.
No, my
Not this, my lord, this is completely one-sided. Everything is one-sided.
The blasts are taking place.
Blast, my lord, the blast is on this fellow's mine. Mine is closed.
So
My
thank
mine
God
is,
that,
my lord, my mine is closed.
thank God that they don't say it's natural tremors.
No, I am not a natural rebel, my lord. My mining is closed. My lord, the High Court, with respect, went only by that report. I got no chance, my lord. I want to show you why would the High Court entertain a PIL at the instance of a next door crusher? Number one. Number two, we have litigation pending between us. Also, my lord, he has filed a suit against us to stop my mining because, my lord, because of competition. He has filed a suit also. All that is, my lord, not mentioned. He files, my lord, if he has a problem, I had, my lord, all ECs and everything I had. We had a problem, we had to go to NGT. So he takes the cover of 3-4 miners, 3-4 villagers, and, my lord, files a petition.
And so far as the blasting part is concerned,
It's the villagers who said.
it's a statement of villagers, not.
Paragraph 45.
Yes, yes.
It is in that vicinity.
That report, if we see.
It's in the vicinity.
You see paragraph 45.
Yes.
The commissioner himself said that he heard various blasts in the nearby area suggesting widespread mining. We agree with you that it may be you, maybe your
Ours is closed. Ours is lying closed. We have filed a
theoretically closed, legally closed, illegally continued.
On papers.
No, but there were two more minor. Just the petition, if we see.
But
there were,
see para 45. Justice Bagchi said, not see para 45.
Yes, 45. See.
Yes. We have been informed by the commissioner that while he was carrying out inspection, he had various blights in the nearby area, suggesting widespread mining. The mining, my lord, that fellow is doing.
That is why Mr. Rohatgi got the High Court as well settled principles of protection of environment.
Undoubtedly.
And preventive principles have banned all mining in that area. Why are you aggrieved by this order? You give your response to the High Court that you were not the person who was mining, it was the petitioner who was mining or nearby.
Number two, High Court should not entertain a petition, my lord, by a neighbor who's doing the same thing.
Why not? Why not the High Court should not entertain? First time the High Court has, after so many years, mustered the courage and shown the right, probably going in the right direction.
Gone. It's like an ex parte report against me, my lord. This order is entirely ex parte.
I don't want to make any observation because this will create problem for so many people.
You are already closed.
I understand
breach of mining rights. It's already closed.
Absolutely closed.
So now it is the breach of reputational rights.
This all
that someone's illegal mining is hoisted on your.
Now the question will be
carry
compensation.
to the High
Things like that, my lord. Now the issue is not a mining.
Yes, reputation, that you are such a.
Not only reputation, it actually means.
Lord,
it will mean
hanged
economic.
without being hard.
Now, if at all, it has to mean only economic things, Lord. Not
under
reputation.
the rehabilitation plan, which is given in the mining.
We are doing that now.
So that rehabilitation plan approved where the amount has been already identified by the authority and the approval has been given to close with that spending. Under the state law, there is a fund which has been created. The money has to be used for out of that. If these kind of findings are sustained, then there's the violation of the act itself. Then that jeopardizes the whole process of a closure and what the fund is to be used for that. That's the impact.
That is exactly what the High Court has noted. That the mining department was going soft on you. He says that the mining was closed on the ground of unfeasibility, but it should have been closed on the ground of breaches of EC and other ecological violations. That may be incorrect because you are saying that it was an ex parte finding. Go to the High Court and clarify the position.
Around a year back, because the closure doesn't place just like that. It's after the inspection carried.
Beloved, may Lord, may I put it, Lord, bottom line? I will file a response, Lord, as it is stated. Let it be considered, Lord, independently is all I can say, Lord. So I'll go back, Lord, to the High Court because now it's only a question of money. If I have to cover.
For the case, section are permitted to withdraw the petition with liberty to approach and file the response before the High Court. We may hasten to add that the initiative taken by the High Court deserves full appreciation. And let no stone be left unturned. There is no stone left actually there.
But stone is causing problem.
I'm trying to make observation because
says
people will
the
connect me.
Jamabandi is gair mumkin pahar, but pahar is missing.
No, that so far as that area is concerned, I don't think there is even the state has taken a position that the mining is illegal. They say
It's not the question of today.
Please, Manoj.
Now that matter is disposed.
Yes, Manoj, that's
20, 25 or maybe more than that. All political bureaucrats and this mining mafia. These three, that trio has a deep-rooted nexus in this area. Then no investigation will be able to find out the truth, not even grain of truth. You don't know the.
Well, I mean, since this matter is
not even a grain of truth will not come out.
Well, I deeply appreciate the mining and
let the High Court satisfied its conscience that they have done something. But we are telling you nothing will come out because all those who will investigate, all those who will be the inquiry commissions, you will see what they have done. How they will also be.
But at this stage, we are only
yes. If the High Court
heard that
the proceedings, then comes, then we'll see what is to be done.
Very well.
Very unfortunate.
I really don't understand, Mulaz. The High Court says it should be in this department, that department, rules of business. Mulaz, where are we going? With the greatest respect. Whereas this is, so whereas courts will now be examining all this.
Is spending there or here, right?
I don't understand.
We have to observe on that day in other state also.
Yes,
the High Courts are running to.
Well, this is it's a quintessential case of.
Lord, I'm appearing for the petitioner. It's 20 crore, and Lord, it's not a question of 20 crore. Elections are being announced the next week. The assembly elections are happening before 10th of April. Now, before, Lord, on 10th of October 25, this decision was announced by the government. Before that, 23rd of September, the secretary of the political party,
that's all there.
Which the government is running, announces through a letter that all LDF workers be ready to volunteer on behalf of the government to go each house and tell them about the welfare schemes. So the High Court in para 51, the scathing finding, Lord, may kindly permit me to read that. How come the political party in a democracy has to be different?
We are only examining a particular project or scheme launched. What is wrong with that?
Lord, it will.
We are only asking that we want to have an
see
evaluation.
Scheme. Lord, just two things. Allow me.
No, if the state government spends hundreds of crores of rupees on welfare schemes, and eventually a state want to know through an evaluation that have my schemes really worked at the field or not?
Now,
because assuming that elections are there, they want to go before the people telling that look here, though we have been spending so much, these are the welfare scheme, but we have ultimately found we are at fault at so and so place. You would like to improve. What is wrong with that?
Lord, the wrong is, allow me to respond to this. The wrong is, they can go. They means the government, not the party through the volunteers. Lord, may kindly see page 50. Lord, may kindly just see this letter, which they initially did not place on record, which is exhibit P2, which is mentioned in para 51 of the impugned judgments. And it says, Lord, may just permit me to pass this on.
No, it's already there. It's already there on record. Not a paisa has been paid to any of these workers. So, what else? Who will go? They are volunteers. Anybody can be there.
Lord, may kindly see how. Now, Lord, may just see para 1 of this letter, which is 23rd of September 2025. Cabinet decision is 10th of October. But Lord, I would humbly pray no stay because it will become instructive. The whole ploy is that they send the party workers to each house.
Otherwise, it will become infructuous, my lord, because they decided. My lord, we kindly see the dates. 10th of October, they decide that they will have this special PR campaign from 1st of January 2026 to 28th of February. And 28th of February, the elections are being announced. 28 crore, which were never a part of the appropriation bill. Now, my lord, we kindly see page.
Also notice applicable responsibility. Meanwhile, operation of the interim judgment, they put 17th February 2026. State.
Not this PR campaign. Lord, should they send their party workers?
They shall, however, at an appropriate stage, submit a report with respect to the expenditure of rupees 20 crore incurred by.
Absolutely.
Just one humble submission. The party is announcing that the cadre be ready. We are sending you with a government official clock.
So
these are the schemes.
Sometimes some local level political worker, he makes a statement. Does it mean that
secretary of the party
decision taken by the?
But if that is the case, my lord, I will not press. My lord, if that is the case, I will not press. He is the secretary of the party.
The courts are trying to they let them concentrate on their work.
And my lord, he says, just allow me to read the 3 lines of this. It was announced earlier by the government is organizing a survey to gather people's opinion on development and welfare of scheme. Now, New Kerala Karma Sena is being formed to organize this survey. So, the LDF supporters who are willing to come forward, please come forward. Join as a volunteer. And they volunteers go to each house as a government representative to tell that my government did A, did B, did C. But this is a campaign for a political party on the eve of election at a government expenditure. And this is the scathing finding arrived at by the High Court.
Yes, yes. Next item 51.
Brotherhood and security.
Brother is in jail, charge sheet is filed, they issue LOC, let me come back, I'll come back, my lord.
No, when did he go?
Because I went, on February of 25 I went, and charge sheet is filed in 19th of July 25. I had cooperated between August 24 to Jan 25. I have put this, I went there, then I went abroad, and then charge sheet is filed in the charge.
No, which year you went?
22/4/25 I'm added as an accused. 22/4.
So for last more than 1 year almost.
Yes, my lord.
You are absconding.
Look, the absconding part as for what, my lord? I wasn't an accused.
Which court granted you permission to go abroad?
There was no, I was not an accused, my lords. I was not an accused.
An application.
April 2025, I'm added as an accused. February, I go, I've already gone. I've cooperated a year before that, my lords. And now charge sheet is filed against me. The High Court dismisses it saying my custodial interrogation is required. There's no custodial interrogation that is required if charge sheet is already filed. If they want to keep everyone, whoever is involved in this.
Mr. Dave, you can hoodwink the law like this. Why should we protect you?
How hoodwink? I'm willing to, I'm saying I'm making a statement.
Application you are closely watching. Your brother is already arrested.
Yes.
But the application comes that you are also named to be accused. You ran away.
Lords, if they had the state.
If that is the way to provide heaven, we know some of them are
coming. I'm making a statement. My lords, 26th, I will be back. Please put this LOC in abeyance. Consider it after that. I'm not running away. If I had to run away, why would I make that statement?
There is no question of providing this red carpeting to you at the airport. You go, surrender.
No, and I won't surrender. I'll be arrested from the airport itself.
Let it be arrested. If you want, then we can only consider your request of releasing you on regular bail, provided that you come and surrender.
I will surrender. I will come. Let them. I will go to the court. I will surrender. Keep this adjourn it, my lord. 26. Record my statement.
No case to grant interim protection against the arrest is made out. That prayer is dismissed. How is the petitioner? When you are coming?
26th. I will be back.
How is the petitioner returns India and surrenders to the investigating authority?
To the court, my lord. No charge sheet is filed.
No, nothing court.
Charge sheet is filed. What will they do?
Surrenders on so date before the investigating authority, his prayer for interim regular bail, including interim bail. shall be considered in accordance with law.
Lordship, please.
Now, option we have given a conditional package for you to decide now.
That's fine, because I'm very grateful for that package, my lord. Can it be immediately on the reopening? They'll have me for whatever days they have, but then lordships may consider it. Good thing they don't celebrate Holi much in the south, Lord, so it doesn't matter whether I have requested.
Celebrating. By the way, which country are you there?
Which country? Sri Lanka, not very far. Yes. So I was not even. I have not gone to some exotic location. I'll come back, Manoj. I'll come back. Please have it, Manoj, on the reopening after the as soon as reopen. Just 1 minute. Reopening, Manoj. Your lordship is convenient to your lordship.
Next week.
Lordship had dismissed the regular bail of E1 on the ground that he is absconding.
How can this
dismissed regular bail of E1?
That is why we have directed him to appear before the investigating agency. Then what are you trying to indicate to us? So you are opposing his prayer. Then what prompts you to put this to our notice?
No,
I'm fully conscious of it.
We are aware of this.
Considered D was rejected by us.
It's only his stupidity that he has gone. He should not have gone abroad. He could probably protected here.
Absolutely,
If he was well advised, he would have gone and surrendered and got his regular pay.
Before this, that would have been my actually. Please have it, Manoj, reopening any day if it's not inconvenient.
Let after we.
Lordship, please. Oblige me.
Please, Your Lordship. Your Lordship, we are led by Mr. Samrat Nigam. He is appearing through VC. Samrat Nigam.
Against one advocate 6.
Your Lordship will kindly permit me to appear virtually, my lord.
What is the correct?
Lord, the current status is again, Lord, there is no date shown. Lord, it was shown on the list on the 18th of February after we filed this petition. But even thereafter, Lord, it could not be taken up. Again, there is no status showing when the matter is likely to come up. Lord. It's only a one-line request that we're making.
Lord. Date now.
I'm sorry, Lord.
Is there any next date of hearing fixed?
No, Lord, there is no date shown even today, Lord. There is no next date being indicated for listing even now. Lord, like I said, I must indicate while this was pending in your lordship's registry, Lord, it got listed on the 18th of February. Again, did not reach hearing.
Maybe decided, Lord, we have no objection to that. Lord, may fix a date and.
Lord, the only request is that your lordship make a one-line direction that they may hear us on whatever date assigned.
All right, thank you very much for guiding us. Honorable Counsel for the petitioner, PANCHOLI and Constitutional and Additional Solicitor of India, representing the Directorate of Enforcement. Next, for the short issue that arises for consideration is identification of pending regular bail application. That is criminal misdemeanor bail application number 40366/2025. Which is pending before the High Court of Judicature at Allahabad and was lastly listed on 6 January 2026. Next paragraph. The petitioner is an accused in ECIR /LKZO /19/2024 registered at Lucknow zone of ED. The allegations are of collecting more than 522 crores of rupees from home buyers and duping them for not delivering the promised
housing units.
Apartments. The petition was arrested on 16th April 2025. He moved an bail application before the High Court on 11th November,
November 2025.
On November 11, 2025. November 25 was issued. Thereafter, the matter was adjourned to 9th December 2025 and again on 6th January 2026. Next paragraph. It is stated by counsel for the petition that no further date has been fixed by the actor. Next paragraph. Since the matter pertains to the grant of bail, comma, we if the matter pertains to the petition liberty, and it is claimed that the matter has not even been listed after 6 January 2026, comma, we dispose of the specially petition, comma, without expressing any opinion on merits of the petition's claim, comma, with the direction to the registrar judicial of the High Court.
Was 4th of February. 4th of February. Yeah.
February 2026 again. ऊपर यहाँ भी आता है इसलिए we direct the registrar judicial of the High Court to put up the to list the above stated bail application on a date in the week commencing 9th March 2026. We request the land single judge of the High Court to make an endeavor to decide the same at the earliest.
In accordance to law.
We expect that High Court they know the law. Yes.
Maybe it's not. There is no denying the fact that 3 acre 10 guntas was actually it's a earmark for Kabristan.
Where is finding, please? Look at the finding of that case.
Now, my difficulty is 1 acre 9 guntas is now say been the inquiry.
How many times measurements will take place? Local commission will go. The High Court has written a finding of fact. They have nothing to do with.
My lordship, the observation by the High Court which says that there are only 250 people. So in fact, okay, so much of this area is also not required. That's the finding of the High Court.
Yes, when you go to petition, that you are invite, you know your remedy under the. You should go under the Waqf tribunal. And
But this land was actually granted by the government itself.
There are no lisab title dispute with respect to a Waqf property, and declaration that it's a Waqf property because you are asking for the adjoining land also to be declared part of the Kabristan.
I'm not for a moment. I'm actually only seeking as what has been earmarked for me. That's okay. 3 acres, 10 guntas. In fact, as per their records also it says 3 acres, 10 guntas itself.
Please see para 3 and 4 of the High Court.
Please, Lord Judge.
Rather, you can see one para 2. It was the grievance of the petition that a portion of the land of 3 acre 10 gunta where the petition claimed to a graveyard was being enclosed upon. Additionally, it was stated that villagers were using a part of the said land as a road. The court had examined the said contentions and noted that the concerned authorities have found during the joint survey that there was an overlap of lands and a new survey number 73 had been carved out of 27 without keeping the original survey so and so intact. It was found that the new survey 73 was overlapping boundaries. For the aforesaid reason, the joint director regional so and so has allowed the revision application and cancelled Durst of survey so and so, and new survey has been kept intact for use as the burial ground of a particular minority community. So that mistake has been carried out. Now see next, it was found that 1 acre 8 gunta was in possession of the private party and it was not included in the subject land. Thus, the burial ground was spread over approximately 2 acres, and that has been kept intact separately.
My lordship may have 147 for a moment. In fact,
you might have a claim for the more land. For that, you get it adjudicated from tribunal.
Not for a moment. I'm thinking anything not an inch more than 3 acre 10 guntas that's been actually granted to me. The state itself says that that you're it says that the land of what you have is 3 acre 10 guntas. 147 reply of the state before the High Court which says that it's 3 acre.
You have two remedies. If you are satisfied with the total area shown in the revenue report, then you have to go simply for demarcation. You can apply to Tahsildar or whatever local authority, get it demarcated. And your area will be, then you can put your pillars on the land. Demarcation means that at this support you have to be given that much land which is notified for you. But if there is a dispute over the part of the land with the private respondents and some individuals claiming their land, for that you have to go to tribunal, the power of civil court, and get a declaration, adjudication.
My lordship may give me that liberty, I'll exhaust that.
After आदमी की expression consequence for the petition seeks and to withdraw this petition, as he wants to approach the appropriate form for determination of the total land earmarked for the Pakistan and its possession at this court. Consent ordered for it.
Please, your lordship.
May I please?
Milords, we are seeking a passover, Milords. We are being led by
This
Mr.
matter,
Huda,
Milord,
who is
earlier
on his
also,
leg.
Milord, on an earlier occasion, Passover was did not reach. Last 3 or 4 occasions, it is not reached, Milord, and they just stay operating against me for last 1 year.
Well, like, what is the matter? Let us see.
Yes, Milord. Milord, Section 711 has been rejected by the High Court, Milord. Election petition was filed with your Lordship. Kindly see, Milord. Page 2254. What are my averments in the election petition? And his application under Section 711, Milord, under Order 7 Rule 11. There's 2 things I have to show to your Lordship, Milord. I say, Milord, he has not given details that he was proclaimed offender, that he was absconding, and that his properties were provisionally attached. Now, in the 711 application at page 292, Milord, he said these are not in my knowledge. This is a matter of evidence, Milord. That's what the High Court says. It can't be, Milord.
Absolutely. Paragraph 16.
It can't be, Milord.
16 of the order.
Page 292.
Mr. Answer here, see paragraph 16. What you are saying,
yes,
High Court judge accepts.
Yes, High Court has accepted. And High Court said these are the matter of evidence, not 711. He admits, Milord, these are the corrupt practice. And para 9, page 292. Although the averments of corrupt practice have been made out, the petitioner has not enclosed the affidavit in strict sums. And, Milord, at page 295 says these are not within my knowledge. How can it 711 stage, Milord, this can be decided? This is what the High Court says, Milord. It will be decided in the trial. But you would see the High Court judgment, Milord, which at page 13. I'm so sorry.
16, clearly 16. Paragraph 16.
Milords, we are being led by Mr. Huda, Milords. He is on his legs in court 5, Milords. We are seeking a passover, Milord. Milord, I do not have instructions, Milord.
You have heard the arguments. Yes, next.
May I please, yes. Give the copy yours.
Well, few dates would be relevant. I'll just pass on a small list of dates.
Yes, Mr.
Yes, I'm just passing on 2-3 dates would be relevant.
Okay. Okay. Oh.
See, in Panchkula property.
Yes, it's a Panchkula.
Rates are multiplied now.
Absolutely.
I think the skyrocket.
Absolutely. Yes.
2001 agreement. Both sides will recognize this part.
As a matter, my lords, yes.
And when you can sit and resolve, don't allow a property dealer to win between, unless
money.
one of you are property.
Offer some more money.
My lords, I'll speak to my client, but the finding is only one, ready and willingness.
We'll see in paragraph 14.
Yes. Whereas the trial court at page 100 record that I was keeping for this period amount of 8 lakh rupees in a particular account. Bank confirms
It will not be ready and willingness.
No,
3 years, there's disappointing silence. 3 years.
I certainly can
Discussing better you
very well.
give some additional
Well, certainly.
incentive.
I will, well, I rather request my my friend if they
Okay,
can
we
sit with
speak
the
with-
lawyers first, that can be a chances of mediation become higher than the two individual. I'll do that.
Both, first of all, both of you will have to.
Very well.
Just sit there for a cup of coffee and
Exactly.
first you in principle decide that who will retain the property.
Yes, yes. We are in 90% possession of the property since 2002,
Yes.
2000.
We are not saying you should
Yes, yes.
discuss in
We-
court, you
we-
can discuss between you.
Conduct also has to be seen, my lord. 3
Then-
years, he was absolutely fine.
If they are in possession.
No, they are not. They are not. We are in possession.
So, well, I think we will, we
We are in
completely
possession.
appreciate and we'll take a first
trial
option
court,
of it.
we are in
We'll try and explore if settled, that's fine.
Okay, on the suggestion of the parties, unless you consider for the parties to have the matter is up to mediation. The parties the parties shall appear before the Supreme Court Mediation Center on so and so date at so and so time. We then after 2 weeks. Meanwhile, our before the matter is sent to formally sent before the mediation center, it seems to us that an informal interaction between the senior counsel and counsel representing the party is extremely important so as to mentally prepare the parties for an amicable settlement. We have been assured that both young senior counsels will have interactions well before the matter is taken by the mediation center. So that 2 weeks के बाद push this matter off this one.
Grateful.
Mediation after 2 weeks, could it be 3
Make
weeks?
an
Because
idea.
I think some interaction will go from it.
We'll do that.
Because both of us will have to bend backwards to see what happens. Great privilege.
Great privilege.
That's what. Mediation will come.
ये मैटर किसी में लगाते हैं हमारे पास ये मैट्रिमोनियल ट्रांसफर पिटीशन मैट्रिमोनियल
My lord, the respondent husband is already fighting out 2 litigations with me in the district court at Kalyan. He has filed a fresh petition all the way in Gandhinagar. My lord may transfer this matter.
No, but old matter why these are listed? Transfer petition is and पहले वाले भी स्पेसिफिक परफॉर्मेंस के दोनों मैटर के टाइम पे ये दोनों तो गए हमारे पास और मैटर के टाइम नहीं है so as per the official court who is there in the respondent
Sam here, but yeah, my lord Sam for the respondent, and in this matter, actually, what happened is ki I filed a petition under section.
We don't want to know what happened. We only know that mediation has failed. That's all.
That she may be allowed to.
The petition wife seeks transfer of family suite number 169 state 2023 title so and so and so pending before family court Gandhinagar Gujarat to the family court of Kalyan Maharashtra. Very good. Next, where the parties got married on 21st November 2016.
Whatever the rule.
They will be blessed with 2 children aged 6 and 5 years respectively. Both children are under the care and custody of the petitioner wife. It seems that the parties started quarreling. It seems that the parties that on account of marital dispute, the parties started litigating in the year 2021. Most of their cases are stated to be pending in the courts at Kalyan and Maharashtra. Mediation has failed. In such circumstances, the petition wife cannot be expected to leave both the children at home and then travel more than 530 kilometers to defend herself in the divorce petition filed by the external husband. So consequently, transportation is allowed. So and so case is ordered to be transferred to so and so court. Yes, item 32.
My lords, on the last occasion, your
But
lordship had
if I may.
appointed. Yes.
But if I may, Lord, your Lordship had appointed a committee headed by my Lord Justice Dulia. We've received communication from the committee that they require 6 more weeks to finalize the report, and Lord, my learned colleague will tender that to your Lordships. They've already done the inspection, but the report is being finalized.
Where is the order of?
My lords, 19th September is the order by.
Is something Ravi or more? Lordships have the order. Must be here, copy again. Can I hand over a copy of the order, Lordships? Can I hand over the last order? I think Mr. Luthra is referring to this order.
Officers have done. Report completed, we'll file reply to this.
CC CC you taking? In your Justice Gudya committee, CC
is part
was a part of the committee. Okay.
Yes, Lord.
Something very serious.
Lord, we just need, I think, Lord, the committee has asked for 6 weeks. They've done the inspection. The report may be useful for this court to determine the matter, is what we are saying.
In this case, the illegality that had gone on during the mining at the interstate boundary of Andhra and Karnataka was so serious, my lord, that the CEC had given a report saying that these people.
The boundary dispute is not only serious, it's very sensitive also.
That has been settled. But unfortunately, my lord, the CBI investigation that was ordered by this court, and where the CBI filed status reports till 2014, and subsequently in the last 11 years they have not filed any status report. That investigation has gone nowhere. Apparently, my lord, that investigation has been stalled. But not only that, that investigation was with regard to one of these 6 mines. All these 6 mines were operating at the intersection of the interstate boundary. They destroyed the interstate boundary, they destroyed the hills, they destroyed the temples there, etc.
No, all these things must have happened only for ensuring illegal mining.
Yes.
Now, unfortunately, 11 years they have not done anything. What we really or what you expect there at the spot by CBI?
So then your lordship should haul them up as to why have you not completed those investigations? The amicus in his report has also mentioned this, that the CBI had been asked to file status report since 2014. They have not filed any status report.
No, it's now what to do? There is now parallel. There is already a committee constituted by this court.
But yes, and not the committee has done the work. The committee now has to respond back to your Lordship with the report.
This is a separate issue. I am on the illegality of the mining, which amounts to criminality, and that is why, my lord, your lordship ordered a CBI investigation.
Mandate of the committee.
Your lordship, now look at the amicus.
My lord, may I just say this? Lord? May I just say this to just assist Mr. Bhushan? It may be useful if the committee's report comes. That may give light even to other agencies and bring things in perspective.
No, that
hope can be if the committee comes to a conclusion.
Yes.
The committee, of course, will that these are X, A, B, C, D, X, Y, Z were the boundaries.
Yes.
And many activities have gone beyond that.
Yes.
Exceeding those boundaries. Then probably maybe some CBI can revive, otherwise God knows after 11 years what will be there at this point.
Well, in fact, CEC has given a report.
fact,
In addition to that, they are required to demarcate it on the land. Interstate boundary is fixed. Both the states have accepted. Now, my lords, it has to be identified on the ground. For that, my lords, the committee was asked.
Say that both the states are happy, boundary dispute have been resolved, boundaries have been fixed. What happened to those persons who have minted
My lord, that, my lord,
and does in illegal mining?
CEC has given a report.
During the when there was a period of flux and uncertainty and boundaries were not known. You grant lease in suppose Andhra side, and person say that no, this land is of Andhra, actually to Karnataka. From Karnataka side, you grant a lease and he indulge in it. They have happily having last laugh, they have run away.
No, my lords, now the mining has been stopped from 2010. Therefore, my lord said, stop the mining. First, identify the interstate boundary, then identify the leases that have been given, then identify what is the amount of encroachment or violation. Then my lords can take an action. Now, my lords, one of the two mines, earlier CEC also had reported that they have committed large-scale illegality. Therefore, my lords, mining leases should be cancelled. One or two of them, my lords, there are only dumps outside within the margin which my lords have indicated. For those mines, my lords have earlier passed an order saying that they can start functioning subject to payment of some penalty for dumping outside, not mining outside. Now, my lords, the committee appointed by this court on 19th, my lords, was required to identify and place a report before my lords. Some of them are not cooperating, that's why it's getting delayed. My request is, my lords, kindly grant them time so that the report is before my lords and then...
No, that we are granting, we have no doubt about the committee.
No, short time, lords. The request is we have lost these years because of somebody else.
But the committee is asked for 6 weeks. They have to do it. It is not for the state fund. It's for the honorable former judge. They've asked for time. That's why 6 weeks. In fact, we are the ones who wanted the committee created not so that whatever is the truth should come out by an independent body.
Interstate boundary dispute between the state of Andhra Pradesh and Karnataka, states of Andhra Pradesh and Karnataka. It is apparent that unabated illegal minings and unauthorized activities continued at different sites. Maybe even after the mining activities were formally banned in 2010. We are informed that the CBI was addressed to undertake the investigation, but nothing concrete has happened at their front. That's right. Meanwhile,
Your Lordship, I am in connected matter 32.2. We have
matter came up for hearing on 19th September 25. A request was made to this court to constitute a committee so as to fix the boundaries of the leased areas and the reserved forest areas, so as to ascertain the extent of illegal encroachment, illegal mining, and other unauthorized activities. This court consequently constituted a committee added by Justice Sudhanshu Dhulia, former judge of this court, as chairperson. Next paragraph. We are informed that the committee is actively involved in completion of this task and given. How much time, Mr. Luthra?
6 weeks, Lord, 6 weeks. The committee has asked for 6 weeks, Lord, in the last para.
6 weeks more time.
To finalize, to submit the report.
The work shall be completed. Next one. Having regard to the nature of responsibility assigned to it, we are inclined to grant 6 weeks more time to the committee headed by Justice Dulia for submission of his report. We request the committee that in specific, the report may throw light on one eye, whether there is an illegal enforcement of the reserve forest area, if so by whom. Whether the boundaries of the leased areas overlap with the reserve forest areas. 3I. What was the magnitude of illegal mining or other unauthorized activities? Keeping in view the composition of the committee where all state functionaries are also members, we further request the committee to throw light on the estimated loss suffered by the public exchequer as a result of the illegal mining and unauthorized activities. Post this matter on so after sitting.
Your Lordship will allow our impleadment. We are the original petitioner, Samaj Parivartan Samudaya. We had raised this issue in our original petition also about this illegal mining at the boundary. We are seeking impleadment in this matter so that we can assist the court about it.
In fact, that was DTAC. That application was DTAC.
You are there, you can always assist us. Let us see now, much will depend. Now we have clearly indicated. Let us see what comes in report.
But CBI has already investigated. CBI has already investigated, filed a charge sheet. Conviction has taken place. My learned friend may not be aware of that. Conviction has taken place. Conviction of the lessees, my lord, against whom the charge sheet is filed has already taken place.
Conviction of some poor laborer working.
No, my lord. No, the main company.
Who was the person convicted? How much fine was imposed?
No fine, my lord. 7 years conviction, my lord. 7 years rigorous imprisonment. Appeals were filed. And my friend may not be aware, my lord. CBI has already filed charge sheet.
Demarcation was required.
We are not being served with the documents. That's why if we are impleaded.
Your Lordship initially appointed Survey of India. Survey of India fixed the interstate boundary. Thereafter, Your Lordship directed to fix the lease boundaries. And lease boundaries, my lord, Survey of India expressed, my lord, difficulty.
Let us see.
That was regarding Karnataka.
Unless the individual lease sketches are reviewed and revised sketches are issued, Survey of India reported, my lord, to the Honorable Court.
Let us wait for the report, sir.
That the lease difficulty is, my lord, the state government has not issued the revised lease sketches as recommended by Survey of India and as accepted by the Honorable Court. Unless they issue the revised sketches.
You have been very patiently waiting for all these years. Have some more patience.
Very,
we'll do something.
Very well.
Grateful, deeply obliged, deeply.
33.2.
Excuse me. 33.2. Your Lordship, I may be
I'm in
permitted to
33.2.
withdraw this petition, 32.2. I am for the petitioner in 32.2.
In the matter of Shubham Avasti.
No, this is 33. 32.2.2, Your Lordship, if I may. Ananjaya versus State.
They have filed a petition 33 seeking the ownership certificate of that. It is for the.
Look, this is the previous matter. That was the previous matter, Lordship. I may be permitted to withdraw.
देखो भी कौन सा matter उनको withdraw करके जाना.
My lord, there is
33.2.
I'm in 33.2, Your Lordships.
My lord, friend is there.
Please, Your Lordships. One second.
Who is there in item 33.2?
It's me, Your Lordships. In fact, I am in 33.2.
Yes, Mr.
Please, Lordships. My Lordships, in fact, if Your Lordships are pleased to issue notice, say in 2020, Your Lordships. Now, my only difficulty as of now is post 6 years, now service, so say, neither the union nor the states have actually come on record.
Issue that you are raising,
Please, Lordship.
we have dealt with that issue in Nalsa. And in Kerala, I had launched a scheme that was the
Assistance for people animal conflict.
on access to justice for victims of human wildlife conflict 2025.
Please, Lordship.
And that scheme very elaborately deals with how to deal with the wildlife part, how to deal with how to sensitize the persons living in the forest area, and how to really eliminate this conflict. So that an environment where the wildlife and the human being both can survive together. So that entire scheme completely deal with that part. You go and contribute to that scheme. Across the NALSA, we will request NALSA to take your ideas also for giving effect to that scheme.
As your Lordship pleases, I'll anyways participate as far as that is concerned. Now, this is on a larger issue, your Lordship. My Lordships may actually look at what's been sought for. What are the prayers that have been sought for? Now, in fact, if your Lordships were to see, there's another incident which took place where almost around about 9 elephants were killed.
Every day this will happen because there is lack of sensitization, lack of public awareness, there are commercial interests, there are conflict of interest, and I can tell you something more about. I have personally seen certain things. I know about those things also. Those are there on report, official report. That how there is a very systematic invasion by a group of persons also. How they are exploiting the situation. So there are very alarming situations part of the South India in the particularly part of Kerala and other states. This has to be really addressed, but not by through court orders. It has to be through human approach. You have to reach out to them. You have to talk to them. You have to speak in their language, understand their issues, their economic conditions, and how people are alluring them that how it becomes suddenly beneficial if you kill like this or you do like this. They are very serious threat to it.
Well, the system has to be regulated, your Lordship. In fact, let the union come on record and say as to what this got. Now, apart from the 13 states that where there are only 3 have come on record.
The issues sought to be raised in this petition under Article 32 has been, for the time being, effectively addressed by National Legal Civil Authority through a scheme, so and so, so and so. So all stakeholders, including the petitioner, are welcome to give their valuable suggestions to NALSA through its member secretary for giving for the effective enforcement of the scheme and to create a robust mechanism that would help in eliminating the human-wildlife conflict in certain areas, in various areas of our country. Also, with the liberty of formation, commodity petition disposed of.
My Lordship may keep the petition.
May I mention
If I can request, if the petition can be if the petition can be kept pending, your Lordship, I'll anyways make a representation of that.
My lord, I want to mention item 33. One second. There are 3 matters listed today. I'm in 33.1. This is a petition that is confined to captive elephants. My lord, unfortunately, it has got tagged with 33, which I believe, my yes, I can say, it's for wild elephants. Yes, your lordship may kindly detag it. My lord, we are ready to go on. See, orders have been passed. 33.1, my lord, maybe kindly be detagged from 33. Yes. And your lordship may list it on any day convenient to my lord. And my lord, we are ready to go ahead.
We are sitting after lunch. We are coming after lunch.
Yes, yes. 33.1 may be called out after lunch. Very well.
Lord, item 28. My Lord, item 28.
My Lordship, my matter, your Lordship, 33.2, your Lordship. If your law.
2 o'clock.
2 o'clock.
I could get nothing in this.
My lord, item number 33. 33, my IA is listed, my lord. 33.
In your para 16 of the High Court.
Yes, my lord.
How can 7-11 be entertained at this stage?
33.1, my lord, will take it up 2 o'clock, isn't it?
We will take up all matters. We are coming back.
Lord may consider after lunch.
That we are spared to have a lunch and then come back.
Very sorry, my lord.
Lord, I'll also request let it be taken up after lunch.
It's up to right now. After taking lunch, we'll become more late.
My lord may have lunch and then will hear.
My brother has minutely seen for a 16. Come up.
I'm seeking my lordship permission to mention item number 43.1, my lord. My lord, I have some extreme personal difficulty. There is a marriage in the family scheduled for today, my lord. If I can be exempted for, I'm representing the state, my lord, in item 43.1. I've informed the other side also, counsel for the other side is here, my lord.
My lords, I'm here, my lords. My only request would be, this is a long service matter which has been pending for many years. These workers, some of whom have almost retired. I'll just request a short date, my lords. They are in great difficulty, my lords.
All right, all right.
Your Lordship, may I mention? Your Lordship, may I mention item 35? Actually, I have a flight to catch and I think 34 is going to take some time. So if it could be taken up before 34, mine is a very short matter, 35.
We will just wait, we are just coming to 34 in a minute.
33, my lord.
Please have five, yes, Mr. Uda.
28, your lordship, state law.
20 is item 28.
28.
Lord, I have just 2-3 submissions to make for my lord's consideration. Para 16, my lord, first thing it talks about is that I have not disclosed that I have been declared absconding in a criminal case. That's the first and primary allegation. Now, my lord, form 26, in which, my lord, I have filled the information, that only talks about FIR number, name, address, court in which it is pending. There is absolutely no requirement that, and my lord, there is no column in which this information is to be given. That whether I have been declared absconding or not. This is one part. Second part is, my lord, after making this observation, the court says there are allegations in para 21 and 24 of the election petition. The court does not even advert to what are those allegations. And if, my lord, I read just these 3 short paragraphs, it will make out it's not a case. If the facts stated in those paragraphs are taken at its face value, every word is correct, still no case is made out. So while issuing notice, this Honorable Court considered it, found that the order is cryptic, it needs a reconsideration by the High Court. This is not the manner in which a 711 application is to be considered and disposed of by saying that no, there are allegations in para so and so and so and so. So, my lord, with regard to first thing, declared absconding, there is no such column, para 26. Now, my lord, may permit me go to para 21 of the election petition. This is, my lord, at page 272. My lord, just prima facie, taking everything, whatever is stated to be correct. Para 21, it starts at page 272, my lord. Without prejudice to the aforesaid insofar as involvement of petitioner in corrupt practice is concerned, on 5th of November 2023, during the ongoing election campaign amidst code of conduct, Devendra Yadav, that is respondent number 1, held a press conference in Bhilai at his office cum residence situated in sector 5, which intentionally caused damage to the reputation of the petitioner, wherein he made bold, unverified allegation against the petitioner without taking his name directly. However, through various material vividly containing allegation against the petitioner. The said press conference was covered by many media houses of so and so. Such tactics were adopted merely to ruin the election prospects. My lord, I'm contesting against him. I'm not taking his name, but he says indirectly he is ruining my reputation, and that is a ground to disqualify. Now, my lord, on the next paragraph, my lord, then these are the YouTube, etc. links given. Now, para 22 is interesting. My lord, we can see what he's saying, which has been taken into consideration to reject my application. Yeah. During the election campaign, respondent number 1 and his election agent, Dharmendra Yadav, used to influence the voters of Bhilai constituency by using all kind of advertising modes. And one such mode was distributing large number of pamphlets in the constituency in form so and so, evidencing the appointment of Devendra Yadav as election agent of respondent number 1 with annexing therewith annexure so and so. It is submitted that advertisement of election campaign through pamphlet is primitive mode to influence the voters, Therefore, it is necessary to mention that printer and publisher are bound to deposit with the office of the district election officer. Some such pamphlets circulated by respondent number 1 and his election agent are annexed here with us so and so. Now, what is written in the pamphlet? Under caption 34 साल धुंधला आकाश बस करो प्रेम प्रकाश, भिलाई बचाओ एकजुट हो जाओ. ये वही प्रेम प्रकाश है जिसमें लॉर्ड कर्जन क्योंकि फूट डालो शासन करो की नीति को भिलाई में. But these are the slogans, my lord. Now, how is it a corrupt practice under 123? And the court has not even adverted to this material by merely saying that para 21 to 24 and the information that he has been declared. So, my lord, all of this need to be considered by the High Court. 711 is, my lord, a valuable right. If no real cause of action, if no case is made out, my lord, even if I say that, all right, this is all, I own it. But, my lord, otherwise I can't contest election unless I can say all this against my opponent. My lord, what is prohibited in section 123(4), I'm just reading out 3-4 lines from the statute, which he is trying to bring the case. Within 123(4), it says, the publication by a candidate or by his agent or by any other person with his consent. He's not setting up a case that whether I have said it or my agent has said it, or it is all with the consent of the candidate. A candidate or his election agent of any statement of fact which is false and which he either believes to be false or does not believe to be true in relation to the personal character or conduct of the candidate. So, my lord, this is in my humble submission, even if the facts taken at its face value as stated in para 21, 22, 23, it does not fall the case within 123(4). And, my lord, as para 16, the first part is concerned, I want to invite, my lord, kind attention to the form 26 itself. My lord, otherwise, the candidate will say that he has not disclosed that the bail was declined. That information is not there. Or that on a particular date, he did not appear and the court made an adverse remarks. Or on a particular date, he was declared absconding.